Welcome back to another episode of our podcast. My name is David Levine, founder and CEO of ResTech Solutions. And today we are talking about from law to legal finance, how capital, risk, and technology are reshaping the legal industry. And I'd like to welcome our guest today, Dave. And Dave, if you'd like to introduce yourself.
Sure. Thanks for having me, David. My name's Dave Kerstein. I'm one of the founders and managing directors of Arcadia Finance. We're a commercial litigation funding company that's been in operation just a little over a year and a half now. But I have been in the litigation finance industry for quite a while, for about 12 years now. Before that, I was a commercial litigator. I spent about almost 15 years at Gibson Dunn in New York, litigating a range of commercial issues, and kind of bumped into this industry accidentally when it was really nascent back in 2011. And in 2014, I jumped over to one of the kind of pioneering companies in the commercial litigation finance space that was then called Bentham IMF in New York. And I was an investment manager there for about 4 years. Following that, I was a founder and managing director of another litigation finance company called Validity. And then my partners and I raised capital and opened up Arcadia in June of 2024.
And with that, let's jump right into our topic for today. So, as you just mentioned, you had spent decades across both the traditional legal practice and little in litigation finance. So, from your perspective, what fundamentally changes for a law firm when it starts operating at the intersection of law, capital, and risk?
I think firms that do that want to do that or are able to do that are thinking more proactively about the business side of law and not just the legal side of it. And not all lawyers are really trained to do that or think they're adept at doing that. But once you kind of cross into that junction, it's really important to do that. And I think firms on the whole are getting better at it. A lot of large firms have been hiring finance experts, pricing experts. They have whole departments that do this kind of thing now. And so I think they're trying to get better at budgeting and forecasting out into the future, which is always difficult for law firms. And I think they're beginning, many of them, or have been doing it now for a few years, to think more creatively about how to share risk on an asset or a project that's pretty uncertain.
All right, well, great. And for firms that haven't worked with a legal finance partner before, how do you typically explain what Arcadia Finance actually does and where you fit into the legal ecosystem?
Yeah, so I think to answer that question, David, it's important to kind of take a step back for a minute and explain, at least at a high level, what litigation finance companies do. And there's different kind of sides of the industry. Cadia is a commercial litigation finance company. We are primarily providing capital to sophisticated companies or perhaps sometimes high net worth individuals, all of whom have complex commercial litigations, usually against large corporate deep-pocketed defendants. They're using our capital in order to be able to fight on the same playing field with those deep-pocketed defendants. And they're using our capital either on the one hand by a plaintiff or a claimant in a litigation or arbitration to basically share risk on or finance what is a very expensive legal fee and cost budget of these cases to see them all the way through and to recognize their highest value of these cases. Or the second thing that most funding companies do is to provide capital directly to law firms to defray or share the risk when those firms are asked to or want to take on fully or partially contingent matters and are bearing the risk often over a long period of time of not getting funds back into the firm. And so I think it's important to kind of have that kind of initial predicate for this. It's also important to note that these kind of investments, for the most part, are non-recourse, meaning that the funder, once they provide the capital to the plaintiff or the law firm, only has recourse for its return if there is a return in the case. We only have recourse to what we call the litigation proceeds. If we're funding on the plaintiff side, if the plaintiff gets a return by settling or winning a judgment that's collected, or on the law firm side, if the firm collects some sort of contingent fee from their client. That's what the funder has recourse to. Otherwise, they don't have direct recourse to the client, to the firm. It's not like a loan that is automatically has to be paid back at some kind of stated interest rate. The other important feature of litigation finance is that funders don't take any control over the matter. Ultimately, the decisions are going to be left between the lawyer and the client in the case. And funders usually have the right to be paid the return that they contracted for, and the right to be kept appraised of what's going on in the case, regular updates, and if there's settlement discussions to be able to understand what's going on and be able to weigh in with our views. But ultimately, those decisions are going to be left between the lawyer and the client. So at base, to get to your question, litigation finance is really and the products that we offer really serves as a risk sharing tool for clients and law firms. We offer a way for the firms to gain kind of added certainty on revenue and cash flow that can otherwise be really unpredictable, as I mentioned before, whether it be on a portfolio basis, contracting with them directly, or when we're contracting with a client, our business is to pay the bills of the firm. Whereas sometimes lawyers and law firms also often spend a lot of their time chasing clients to pay their bills. When you have a funder involved, it can be a more regular stream of payments, which is helpful for the firm. We also offer the firm a way for them or their groups to be able to enhance their client and revenue base by being able to take on or litigate on behalf of clients with strong claims that those clients would not otherwise be able to afford their fairly expensive rates. And it's also another lever that law firms can pull on in addition to the traditional levers of increasing the hours that their lawyers bill or increasing the rates that they charge their clients. By investing some of their time into these cases and using a funder to help defray the risk, they can actually earn, like funders do, a multiple on their invested time. And it's a way for them to enhance their revenue in a different way. So in short, it's really a way for a firm to take mitigated risk in cases and perhaps take on a wider pool of cases on risk. They get more shots on goal. And for clients, it's a way to share risk on a pretty risky contingent project litigation, save some of their funds to invest in their business and do what they do best, and also be able to hire the best firms and the best experts to try to recognize the most value out of their cases rather than hire perhaps a lesser firm or a lesser expert because they can't afford the top of the heap. Let me give you one example of how it can be really beneficial to a client. So let's say they're a really big ticket litigation. It's a $10 million budget they're being projected by their lawyers, and the case is worth several hundred millions of dollars, but everybody thinks they can resolve the matter at the end of the day, maybe for $100 million. Pretty big ticket litigation. If they just funded it themselves, they fund that $10 million over a period of 2, 3, 4, maybe 5 years. There's an uncertain outcome. They might lose it all. They don't have that $10 million to make their widgets or do whatever the business otherwise does. But if they win, they settle the case for the $100 million that they predicted, they get a nice 10x return on that money. So that's nice. But if they use funding instead, a funder picks up almost all, perhaps all of the $10 million fee budget. A lot of funders will ask the client to contribute something to the exercise so they have some skin in the game. So let's say it's $100,000 to some of the costs in the case, which is a common thing that funders will do. Okay, so now the client has risked $100,000 on this project, but they have that $9.9 million that they otherwise would have spent on legal fees across the case to go invest in their business and make whatever their profit margin is on their usual business. And if they succeed at the end of the day and they recover $100 million, they're going to have to share that with the funder, and they're going to have to share that with the lawyers who likely took risk in the case. Instead of getting $100 million in their pocket, maybe they gave $30 million to the funder because the funder had a 3x return on their $10 million. And they gave another $20 million to the law firm who had a 20% contingency interest in the case. Now they're left with $50 million, but their return on investment is a lot higher. If you divide $100,000 into $50 million, you get 500x, right? Plus they were able to use that 9.9 million to go run their business. So it can be a really valuable tool for both lawyers and clients.
Oh, great. Appreciate that. So it sounds like for on the funder side, obviously they're taking on risk. So my first question is, and so you just kind of said this last piece, why would someone obviously want that risk? But obviously it sounds like they get potentially some sort of, when there's a payout, some sort of guaranteed return as well for their participation, essentially, if I'm understanding correct.
The funder that you're talking about the funder?
Yeah, so the funder that would put up like that 100 million or whatever that amount, or the
Right.
10 million.
The 10 million in my example, right? No, the funder doesn't. I think it's a risky proposition for funders. So we don't have a guaranteed return. What we do have is if the case is successful, we'll usually have the right to some sort of priority return in the waterfall of payments of how you divide up the $100 million that came back. And funders will usually have some sort of specified overall return that it can be a percentage of the proceeds, like 20%. It could be a multiple of what we've deployed into the case, which is kind of common. It could be some sort of combination of the two, a smaller multiple and a smaller percentage. So in the example I gave, I said the funder was getting 3x. So maybe that was their stated return. Sometimes funders will say, I get the greater of X or 20%. And that might actually, it might start lower to try to encourage there to be an early resolution. So I might say, if you guys can resolve this case in a year, you only have to pay me 2x or 15%. But if it takes 2 years or more, maybe then it ratchets up to 2.5x and 20%. And if it takes 3 years, maybe it's going to be 3x or 25%. It's sort of that's a common way to do things. Another way to do things is to add, as I mentioned, a smaller multiple, a 2x plus a 10%. And so funders will look at the kind of risk and their perceived value of the case and try to come up with a return that compensate the funder for taking quite a large risk in the case. Most reputable funders will also try to make sure that when they structure, and we try to do this, when we structure the return, we're not taking every last nickel. We want there to be a healthy return going to the client because first of all, it's just a matter of fundamental fairness. It's their claim. And if we're taking every last nickel all the time, that would look pretty bad for us. But also, we want to incentivize the client to be able to resolve the case on a reasonable basis, on a reasonable time frame, because that cuts off the duration for us. It also cuts off the risk. If you can settle the case before going all the way through trial or appeal, that's a less risky proposition for us. So we try to structure it so that the plaintiffs or claimants in an arbitration are going to be getting at least 50% or 60% or more of the proceeds. It's no guarantee, but we look at the various scenarios and try to come up with a reasonable return scenario that will allow them to recover some amount of money that's significant to them. And we also want the law firm who we're usually, not always, and not all funders, but many funders will often ask the law firm to take some risk on their fees. And so if the law firm is taking risk on the fees, the law firm is going to get some sort of partial contingent return in the case as well. And we want that to be valuable to them so that they're incentivized to litigate the case to its highest natural resolution.
All right. Well, perfect. I appreciate the additional insight. All right. And let's see. And I know some of these questions, because you gave me a lot of information, may have covered some of these, but I want to ask anyways, in case there's anything else we're missing. As firms grow and take on more complex matters, what operational or financial gaps do you see most often before they engage with a finance partner?
I think the ones that aren't as sophisticated or haven't done this, sometimes don't have or haven't thought through enough of a proper understanding of the real timing and the risk when they're budgeting the case. There is a little bit of a sweet spot. You want to make sure that the budget is realistic and has some cushion to be able to survive uncertainties that inevitably arise in these cases. But it can't be too high. If the lawyer is sort of giving too much of a cushion or padding the budget too much, it could make the funding impractical because most funders have a fairly common rule of thumb across the industry that we want to see that the true value of the case, what you can resolve it for, not necessarily what you're asking for, is going to be about 10x of whatever we're being asked to commit. So going back to my prior example, there was a reason I said $10 million commitment, $100 million expected resolution, because that fits nicely into that 10x metric. If the budget is too high, if they were like, well, I might as well just say the budget's $20 million just to be safe, that might make that project untenable for a funder because it looks like there's not going to be enough proceeds in there and the reason for the 10x metric is to make sure there's enough in there for the funder to get their return, for the client to get their 50 or 60%, and for the law firm to get its contingent return for having taken risk. So you have to be careful, but you can't have it be too low because if the budget is too low, then the law firm's going to exhaust the budget too early in the case, and they're going to be on more risk than they really anticipated because most funders are operating on a cap. We say, you give us the budget for the case for fees and costs, we're going to commit whatever percentage of the budget we're agreeing to commit. Maybe it's 50, 60, 70%. But when you reach that cap, you law firm are on risk for if you go over the cap. And you're being compensated for that by the contingent or partial contingent fee you have. But it's a way to try to keep law firms operating efficiently as possible. And also funders have a finite pool of capital we're working with, and we need to know how this particular project or opportunity is going to slot into our overall portfolio. So we need to know how much it's going to cost. And if it keeps going up and up, that's going to be difficult for us to manage our portfolio. So not having a proper understanding of the timing and the budgeting can be a problem. Not having the second kind of problem that I see at firms that aren't as sophisticated often at taking risk or using funding is not having mechanisms in place across the firm, especially when they're larger firms, to share risk and on the investments that the firm is making in these type of cases. Part of it comes from Partnerships often are distributing all their profit at the end of the year. And there's partners at different levels of seniority who may or may not be around in a few years when some of these cases are expected to resolve. So there can be partners who have different views at some law firms about whether it makes sense to take risk in cases that are not going to resolve for 3 or 4 years and you're not going to be fully rewarded until then. And so not having some sort of mechanism in place to deal with partner and associate compensation in cases that are on risk can be a problem.
All right. And from a risk standpoint, what separates firms that are well prepared for growth from those that struggle once funding and case volume increases?
I think two things really. I mean, first, I'd sort of go back to what I just said a moment ago, being able to properly budget and assess the risk in these cases and being able to think about recovery in the cases and not just winning the case on the merits. A lot of lawyers are trained in law school, like we're focused on, we're going to win this case. Okay, great. So you get a piece of paper at the end of the day if you don't settle it that says you win $100 million. But if you can't collect that $100 million, that piece of paper can be kind of useless. So being focused not just on winning the case on the merits, but how you're going to monetize the case is really important. And frankly, a lot of this just comes, my second point I would make an answer to your question is from experience. Firms that have done it a little bit or a lot are a lot better at it.
Well, great. And transitioning a little bit here, a little less on the business, more to you personally. What do you enjoy most about your role today, especially compared to earlier stages of your career in law and finance?
Sure. I mean, first off, the mix between law and finance, has been super interesting and fascinating to me and a learning experience. Back from when I was a litigator, I litigated cases and didn't really focus on the business of law at all or the finance side of it. And being exposed to that, now also running my own business and building my own business has been a really rewarding experience. It was something I thought I wanted to do something more business oriented and entrepreneurial when I was in a big law firm. I didn't know exactly what that was. But once I sort of found what I wanted to do, it's been a really rewarding experience. I still get exposure to what I always found to be the most interesting things that I did as a lawyer, which is work with clients to help them solve their problems, issue spot on and try to come up with answers on interesting and complicated legal problems. But I also don't have to, sit here and be writing a brief at 2 in the morning because I have a deadline from the court, which is nice. Working with a cross section of really the best and smartest lawyers in the world, which is who we want to work with and fund cases with, has been a great experience and really helping to educate them and helping to educate clients about this still somewhat new tool of litigation finance has been really
Well,
rewarding.
it sounds like it. I mean, like so far everything you said I found very fascinating because even as much as I've kind of started working with the legal space, I still am learning a lot about it, and to me, this has been extremely fascinating.
The lucky thing for me as someone who has to go out and educate the world is most people seem interested in it. So even at a family barbecue, people are like, "Oh wow, what is that? Tell me a little bit about it." So it makes it easier to talk about it because it's somewhat new thing and people are really interested. And I think most lawyers and clients who end up using it for the first time or dabbling in it or using it a lot generally find it to be a positive experience and see the benefits. Are there bad stories? Are there bad apples? Are there bad experiences? Of course. But on the whole, I think most people find it to be a useful tool. And I think that's why it's really kind of grown and sprouted roots in the legal industry.
Appreciate that insight. And this next question is one of my favorites. I love asking all my guests. But are there any major initiatives that Arcadia is focused on right now, whether that's scaling, new funding structures, or deeper collaboration with firms?
Well, first off, we're probably going to be moving into a second phase of Arcadia soon, where we're raising new capital for the company. So that's exciting. But I've been now, as I mentioned at the outset, been in this industry for about 12 years, and for the most part, the products have remained the same. There's that commercial litigation funders offer. There's some slight different tweaks and flavors that different funders offer, but for the most part, they're kind of similar. But I do think that there is starting to become a change. I can't speak specifically to the product we're working on until we take it to market, which should be soon. But there are a couple of new products that we're working on that we're still kind of tweaking the structure of, and that would be kind of almost an entirely new product, but is sort of more in the business of law than in the business of just funding a particular case. But it is a product that should allow for deeper collaboration with law firms to help meet some of the needs that they're facing these days. And we do hope to bring that to market soon.
All right. Well, no, that sounds phenomenal and very interesting to look forward to hearing what you have to come out with. once you're ready. So I know we're kind of approaching time. So I think this is probably a good place to sort of wrap a little bit. But before we do, are there any final thoughts or advice you'd like to leave the audience?
This has been a great discussion. I really appreciate you having me on. I do think the intersection of business, law, tech is really an interesting space and continuing to evolve. We haven't really touched much on the whole AI revolution, which lots of law firms are now at least dipping their toes in, if not more, and a lot of funders are exploring as well how it might help their businesses on the operational or the sourcing or the evaluation side. I don't know that anyone's gotten it exactly right yet, but it should be an evolving area that I'm sort of interested to see, how it evolves over the next, few years.
Yeah, and I can say from all the conversations I've had doing this podcast, with a bunch of lawyers, coming on, it has been a recurring theme. AI. I can tell you a lot are looking at AI right now. Probably the most common bit is how to use it to see or gain efficiencies in their operations. So taking a lot of basically those menial tasks and basically freeing up human capital for other areas where it's greatly needed. That's I think where probably most firms are at right now with AI. I know there are some that are kind of exploring it more with the use with some other backend systems to help automate and do research is another big area I've heard people mention as well. But I know as we go over time, that will evolve because it seems like every day there's something new with AI. So it's always something I like to ask on these discussions because there is so much going on right now, especially in the legal field.
Yeah, I mean, and from a funder's perspective, the more efficient law firms can get, the better for everyone. It'll ultimately lead to a better return on investment for everyone involved in a sort of funding dynamic.
Well, Dave, so appreciate you coming on. This is an extremely interesting and enlightening conversation. And for anyone else who would like to know more, we'll have all the information in the chat on how you can reach out, get to their website and find out more.
Thank you, David. Thank you for having me.